What happens to the deceased estate of an unmarried cohabitating partner who died without leaving a valid will? How will the deceased assets be distributed? Who is entitled to these assets? Is it the family, or the surviving cohabitating life partner? Let's find out. Welcome back to the Jurist Prudence channel, the home of South African summarized case laws. It has been over a year of educating, entertaining, and skilling our viewers. Your comments have kept us strong and continue to encourage us to keep improving our content. You should know that we highly appreciate your presence. If this is your first encounter, feel free to feel at home. Like, comment, and share this channel with your colleagues. And if you're about to subscribe, ensure that you also enable your notifications by smashing the bell icon. Please do so to avoid missing our community posts. When a person dies intestate or without a valid will, her assets are inherited according to the rules in the Intestate Succession Act, 81 of 1987. The rules of intestate succession are used to determine suitable beneficiaries who are to inherit the assets of the deceased. In the recent case of Bwanya v. Master of the High Court, the applicant and the deceased were living together in a permanent, opposite-sex relationship for a period of over 2 years before the death of the deceased. The two had undertaken reciprocal duties of support, with the deceased providing financial support and the applicant providing love, care, emotional support, and companionship. They were committed to marrying each other and would have been married, had it not been for the practical challenges regarding the payment of lobolo to the applicant's family in Zimbabwe. The deceased died unexpectedly before he and the applicant could travel to Zimbabwe to finalize the bride's price arrangements with the applicant's family, after which they would have been married. The court declared that the applicant and the deceased were, at the time of the deceased's death, partners in a permanent opposite-sex life partnership, with the same or similar characteristics as a marriage, in which they had undertaken reciprocal duties of support. Section 1(1) of the Intestate Succession Act was declared unconstitutional, and invalid insofar as it excluded the surviving life partner in a permanent opposite-sex life partnership from inheriting in terms of this act. It was then upheld that the Intestate Succession Act is to be read as though the following words, or a partner in a permanent opposite-sex life partnership in which the partners had undertaken reciprocal duties of support, appear after the word spouse, wherever it appears in the section. Partners of the opposite sex in a permanent life partnership who had undertaken reciprocal duties of support, were excluded from the application of the extension of the definition and could not inherit as intestate heirs. Opposite-sex life partners in a permanent relationship, who had undertaken reciprocal duties of support, qualify as intestate heirs. If you found this video informative, and it wasn't a waste of your time, please like and share this with your family and friends. If you have not enabled your notifications, please consider doing so, to keep in touch with us. Take care. This is the Jurist Prudence channel. Forever your law buddy, until the jury do us apart.